Welcome back to Real Estate Without Agents, the playbook for homeowners of the information age. I'm Rock, Florida, and before we get into today's topic, a quick and important disclaimer. I'm not an attorney. I'm not a CPA. This is not legal or tax advice. I'm just a guy that has been learning these lessons on the battlefield for over 20 years so that you don't have to. What this is guidance based on more than 20 years of real world experience helping homeowners navigate real transactions, real disputes, and real consequences. And some of the best counsel that I have ever received from the best broker and supervisor that I've ever had, Miss Janet Braden, was, how does this sound to the judge? Now, here's why today's episode matters. In this due diligence series, we're going to talk about preparation, inspections, documentation, all of it. But if you do nothing else, if you skip over half of what we discuss, if life gets busy and your preparation gets delayed, this is the one document you should assume will eventually matter. Because this is the document that most often resurfaces later, sometimes long after the sale. So we start here, not because it's exciting, not because it's fun. Those episodes are coming soon because it's foundational. Preparation isn't paranoia, it's responsibility. Be prepared, Scout. The seller's property disclosure, or the SPD for short in the industry vernacular. Let me start with a couple stories that illustrate exactly why this matters. Recently, in 2025, a Washington state appellate court revived a lawsuit involving a home sale where the seller had long known foundation and soil movement issues. The seller had engineering reports going all the way back to 2003. Those reports documented structural concerns and soil movement under the home. The issue wasn't that the house had problems. The issue was that the severity of those known problems was not fully disclosed to the buyer. After the sale, structural damage appeared. The buyer sued for fraudulent concealment. A lower court initially dismissed the case, but the appellate court brought it back. Why? Because failure to disclose known material defects can create legal exposure even years later. This case isn't about perfection, it's about honesty, memory, and documentation. And it's far from rare. Just Google recent real estate lawsuits. And when I did that today, this is one of the first things that popped up. An example from a recent Reddit thread. This guy had recently bought his dream home in Georgia, went to his first HOA board meeting, and this is a short excerpt from his thread titled, "Am I able to sue the prior owner?" I attended and found out all the residents were asking me why we bought this house. Apparently, there's going to be a huge road extension starting soon, adding another road right next to my fence. I was shocked. If I had known, I wouldn't have bought the place. Regarding the easement, correct me if I'm wrong, but on the seller's disclosure, under the question, is the property subject to a threatened or pending? They said no. The previous owner knew about this because they had been in meetings and received letters since 2022. Is this something I could sue the owner over? I'm super upset and feel like I got cheated. What do you think, folks? Should he sue? How would that sound to the judge? Now, let me bring this out of the headlines into real life. In my own career, I've had transactions that required navigation and mediation, not because sellers were trying to deceive anyone. I hope. Most weren't. What I've seen over and over again are issues like prior water intrusion or water damage that only happened once, structural concerns that were partially repaired or temporarily mitigated, repairs that were assumed to be permanent but weren't, insurance claims that sellers forgot about or didn't think were important, and very commonly, unknown or misunderstood HOA restrictions or covenants. Things like rental limitations, parking rules, pet restrictions, architectural committees, use restrictions that didn't bother the seller but mattered deeply to the buyer. In almost every case, the seller didn't intend to mislead. They forgot, they minimized, they didn't recognize the issue as material to anyone. But here's the hard truth. Intent is not required for exposure. Disclosures exist to capture truth before memory fades. Most sellers approach the seller's property disclosure like it's paperwork, a box to check, something the agent handles. There's a dangerous myth in real estate that says, if I say less, I'm safer. The reality is the opposite. Ambiguity creates interpretation. Silence invites assumptions, and assumptions create disputes. The SPD isn't just a form. It's a defensive record of good faith. Let me clarify something important about my role as an agent. In more than 20 years, I've never had post-sale negative recourse tied to disclosure failures. Knock on wood. That's not luck, that's discipline around rigorous honesty. But there are limits to what an agent can do. I cannot tell or assist a seller in how to answer disclosure questions. Even if they're deaf, dumb, and blind, or just confused, overwhelmed, or inexperienced, maybe you can get a family member to help you. The instructions are clear. The seller must read them and answer to the best of their knowledge. And here's the other side of that coin. If I know or later learn about a material issue, I am legally required to disclose it, regardless of what the seller writes. Honesty cannot be delegated. Responsibility rests with ownership. So let's define this simply. The SPD is a snapshot in time of material facts you know today about the property. It's not a warranty, a guarantee, or an inspection. It does not say your house is perfect. It says you're willing to tell the truth clearly. That posture matters. If you know about it, tell them about it. That single principle protects more sellers than any legal trick ever could. And here's another misconception that causes problems. The disclosure does not need to be completed before proactive marketing. In fact, it shouldn't be rushed. This document is the end product of your due diligence, not the starting point. When sellers rush disclosures, issues are forgotten, answers are incomplete, and later corrections raise suspicion. Preparation comes first, and documentation follows. Here's another mindset shift. The SPD is not a once and done declaration. It's a living record. As you own the property, you learn more, you fix more, and you discover more. Updating a disclosure isn't a red flag, it's stewardship. Clarity improves over time. When you sit down with this form, slow down. Ask yourself, would I want to know this as a buyer? How would this sound if read years from now? And ultimately, how does this sound to the judge? You are not required to investigate, but you are required to be honest about what you already know. Certain categories generate most disputes: water intrusion and drainage, structural and foundation issues, roofing claims and history, prior insurance claims. Don't get me going on how many issues that the racket that is homeowners insurance can raise. We will get to more to that in later episodes. Environmental or health concerns, permits and additions, HOA rules, covenants and restrictions, and mineral rights and land use. If you're unsure whether something matters, it probably does. Here is your action step for today. Download a generally accepted seller's property disclosure form from your state of residence or the one provided in our resources. Don't fill it out yet. Review and familiarize yourself with it. Separate what you know from what you don't. Open your due diligence folder, place your SPD inside, and get ready for a much better night's sleep. This content gives you understanding. The resources give you structure. Coaching gives you judgment and pacing. Honesty isn't something you outsource. Stewardship is personal. In the next episode, we're going to talk about ordering a pre-inspection report, ideally 2 to 3 months before proactive marketing, or at least before a buyer orders theirs. Why? Because independent third-party professionals help you discover what you don't already know that should be on your honey-do list. Your memory mist, validate assumptions, and strengthen your disclosures. The more you know before the buyer shows up, the more profitable and de-stressed the transaction becomes. If you have any questions or comments, please feel free to drop them on me. I'm Rock, Florida. This is Real Estate Without Agents. I'll see you next time.